Um, First of all, a little bit of bad news to our speakers. I've been asked by the organizers to try to chop about 5 minutes off the session. So could I ask the speakers to aim to speak for about 5 minutes? And so you don't get summarily cut off. I'll just give you a little warning when it's a minute to go so you can get your thoughts together and conclude. Well, anyway, such housekeeping apart, today's session is alternative dispute resolution mechanisms to reduce the burden on the courts and in consequence to improve the access to justice. I might make a preliminary observation that we shouldn't see ADR as purely a diversion mechanism, which simply takes pressure off courts. I think we should really see ADR in all its forms, and mediation in particular, as actually a good in itself. Mediation can lead to constructive solutions which courts can't give, and can often leave what were bitter enemies, well, if not the best of friends, at least prepared to cooperate going forward. But so I think we do have to bear in mind that there are these two aspects. And to talk about them, the first of our speakers is Professor Dr. Lorena Bachmaier, and she is a professor at Complutense University in Italy. She's written extensively on a variety of subjects related to procedure and human rights. She's an ex-fellow of the Alexander von Humboldt Foundation and a visiting scholar at a huge long list of universities, which just leaves me with my jaw dropping. So impressive is it? But she's also the recipient of the Luis Portero Award for the best legal study on fundamental rights in Spain. So I can't think of anybody who is better equipped to talk to us about the subject of how one can constructively resolve disputes and take the pressure off justice. So, Dr. Bachmaier, your 5 minutes starts now.
So thank you very much. And I will talk, thank you. I would love to be Italian, but I'm Spanish. But apart from that, Ayan, thank you very much for this introduction. And thank you, of course, to be invited to this important session and with 88 participants, which is amazing. And of course, thank you for the Council of Europe to have me as one of the partners in this important project on twinning of lawyers. So very quickly, because it was 7 minutes, but now we have 5 minutes. And I tend to talk too much. I only want to focus on two issues very quickly. First, the relationship with ADR and human rights. And human rights, when we talk about this, and this is one of the title of this panel is, back in 75, the court already said one can scarcely conceive of the rule of law without being there the possibility of having access to the court. So within that context of safeguarding access to the court, we see that the increased litigation in all areas makes it impossible for the judiciary to deal with all cases. So that has been already very much commented this morning, and we are all very much about. So this leads to pushing forward to reduce the workload, but as Ian said, not only because it makes the life of judges easier, but it has its benefits of its own towards agreement-based ADR, adjudicative ADRs, or mixed ones. No, and the present moment, the debate is not which justice is better, the alternative out-of-court justice or the others. They are complementary solutions. And this has been underlined by, I just mentioned this human rights study on empirical friendly settlements before the European Court of Human Rights in its practice. And so we have to see it as a very, very useful tool. My presentation here, and it's not recalling what are the recommendations of the Council of Europe. You all have them online on the page, on the web page, and I'm dealing only in this presentation with ADR in civil and commercial matters, because if has it been seen in practice, In criminal matters, they are very useful to promote restorative justice and rehabilitation, but not so much in reducing the workload of the courts. And I want to stress also the importance right now between the relationship ADR and ODR, so the online dispute resolution. There is a very important document of this year, of 16 June 2021, by the Council of Europe, with the guidelines of the Committee of Ministers of the Council of Europe on online dispute resolution mechanisms, which is mainly addressed for what are the kind of safeguards and cybersecurity that have to be adopted in online dispute resolution, judicial, but the same principles are to be applied in ADR proceedings. So I would recommend everyone to have a look on these guidelines, because online, what we have seen last year, but the pandemic has and will stay. So a shift toward a digital online dispute resolution is advancing, progressing, and will be there in place, has arrived to remain. So the two main questions I wanted to, from the point of human rights, is what is the role of the judges, which is my presentation, and the ongoing discussion between mandatory resort to ADR or not. When we're talking about ADR, the best obviously is that it is made absolutely voluntary. This is the main step for make it successful. Of course, in order to be a system of mandatory ADR legitimate and proportionate of restricting the access to court, there have been strong discussions in England and Wales for imposing sanctions for not going to ADR before introducing or filing a lawsuit.
A minute to go.
Yes. And just to remember that this is possible under the European Court of Human Rights, mandatory, as long as the factors are not delays, not too much fees are respected. With regard to the role of the judges, I would recommend you to just read this opinion of the Consultative Council of the European Judges on fair trial within reasonable time, but taking into account alternative means of dispute settlement. And the main principles are that the judges should have the power to refer to ADR, and the role in certifying or controlling, supervising if law enforcement is necessary to enforce ADR agreements. So that would be my presentation in 5 minutes. There is obviously much more to say, but I won't take the time and make your life even more complicated, Ian. Thank you very much.
Well, thank you. Brilliantly done and wonderfully encapsulated into the time. Our next speaker is Dr. Remigijus Jokubauskas. I'm sorry, my Lithuanian's not terribly good. I hope I got it right. And Dr. Jokubauskas has actually recently successfully defended his doctoral thesis on the exercise of collective creditors' rights in corporate bankruptcy proceedings. He's from Lithuania, and he is, I think, well equipped to give us a Baltic perspective on the issue. So, Dr. Jokubauskas, it's over to you.
Hello, good afternoon, everyone. Indeed, it's great pleasure and honor to participate in this conference as well. I would like to share my screen and show you also the slides of my first presentation today, and just let me know if you can see them. Can you see the slides?
Yes.
Good. So I will be also as short and precise as possible of my presentation, and I would like to discuss one particularly important aspect of ADR procedure. It is confidentiality of these procedures and how confidentiality should be protected, who is responsible for protection of confidentiality, and other relevant aspects. So it seems that it is commonly agreed that confidentiality in ADR is an important aspect of effective dispute resolution mechanisms and for protection of the interest of the parties. It also seems that the mediators have the duty to ensure confidentiality of these proceedings, but nevertheless, the level of protection of confidentiality, what information is confidential and how it should be protected is quite different worldwide. So I would like to raise four main questions regarding protection of confidentiality in ADR, which namely are, so what information is regarded as confidential? Are there any exceptions to the protection of confidential information? Who is responsible to ensure confidentiality of these proceedings and how it should be protected? And let me try to give answers to these difficult questions by giving some examples from the soft law documents of the Council of Europe and the regulation of the European Union and different countries worldwide. So turning to the documents prepared by the Council of Europe in the area of alternative dispute resolution, it seems clear that since the first document, the first recommendation on mediation in family disputes, confidentiality of mediation was emphasized. And since then, the Council of Europe emphasizes the importance of protection of confidentiality. For example, in 2002, in another recommendation on mediation civil matters is the same. It's also emphasized that information used in mediation is confidential and should not be used subsequently. Similarly, in the latest development of ADR in the works of the Council of Europe, it's mentioned that all information associated with mediation is confidential, and namely mediation providers should take all responsible steps to protect this information. Turning to the legislation of the European Union, it's also quite clear that confidentiality in ADR procedures should be protected. The main legal document in the European Union governing mediation procedure is, of course, the Directive on Mediation in Civil and Commercial Matters. And the goal of this document is to facilitate and increase the use of mediation in civil cases. And namely, Article 7, Paragraph 1 of this directive regulates the main aspects how confidentiality should be protected in the ADR procedures in the member states. So it is also recognized in this article that mediation procedures should be confidential, and not only mediators, but also administration, persons involved in the administration of mediation process also have this duty to ensure confidentiality of mediation procedures. But there are two notable exceptions to this general duty. First of all, it is exception of public policy, which may not require to ensure confidentiality in case this information is important and necessary for other proceedings, for example, for criminal proceedings, and also when such information which is regarded as confidential is important for the enforcement of the agreement which the parties reached in the mediation process. One of the examples of the legislation on confidentiality of mediation in European Union can be the regulation of mediation in the Republic of Lithuania. Article 17 of the Law on Conciliation of Civil Disputes of Lithuania clearly establishes the duty for mediators to ensure confidentiality of the information which was revealed in mediation procedures. So it kind of reflects the general guidelines established in Article 7 of the Directive on Mediation. Similarly, the protection of confidentiality in mediation is clearly emphasized in the case law of the United States courts. Though there is no one common legislation on mediation in the United States, the courts in the United States...
You have about less than a minute to go.
Okay. And the courts in the US have constantly emphasized that it is important to protect confidentiality of mediation in order to promote the free flow of information and ensure integrity of ADR. But again, in the US legal system, there are exceptions when this information in mediation can be revealed. And basically, these are exceptions when the outweighs of other legal interests are more important than protection of confidentiality of information in mediation. And finally, just let me give some summary of those questions which I raised at the beginning of my presentation. So as you can see, I believe from the regulations from different countries and the soft law documents, that as general rule, all information in mediation is regarded as confidential unless the parties agree otherwise. Exceptions to this rule should be established in the law, and namely the mediators are responsible to protect this information and take all necessary measures to do so. So that's it for my presentation. I hope that was useful and practical, and thank you very much for your attention.
Thank you very much. It's an interesting thought that, you know, the value sometimes that there is in confidentiality, because of course, litigation happens by and large in the full glare of public publicity, and it can actually end up prejudicing the sort of frank discussions that are needed to achieve a resolution of a case. Our last speaker is Dr. Hayk Hovhannisyan, who is a member of the Supreme Judicial Council of the Republic of Armenia. He was elected in 2018 by the Armenian National Assembly as a prominent lawyer and scientist to serve. He's got over 20 years of multi-jurisdictional experience, Doctor of Philosophy in jurisprudence, and is a very well regarded lawyer in Armenia. So he will give us, I hope, an entirely interesting and slightly different perspective. Dr. Hovhannisyan, it's over to you.
Thank you, Jan. Hello, dear participants. I will stick to my 5 minutes. Okay, so here we go. First of all, I would like to focus on dual role of lawyers in mediation. And that is, you can act as a lawyer, as a party representative in mediation, or you can act as a mediator lawyer. As we know, mediators do not necessarily need to be lawyers, but usually it happens as well. So it's a dual role, and given the role, if you are a lawyer or a party representative or a mediator, the ethical challenges may differ, and so you have to be very careful about it. So that's why you need to train yourself and be aware of the differences, because if as a lawyer you do your best to give a day of court for your client, and you take a second role and you leave your client as on a first role, and you do your best to achieve the best solution for your client, you have a significantly different role as a mediator, where you have to be neutral and impartial and maintain the powers for all the parties engaged. And then having said, I have to say that as better you know about mediation, and as much you know about mediation through special trainings, then there is a better chance that you as a lawyer will become an ambassador, and you will start to advocate mediation and ADR and European Association of Lawyers and professional associations like Armenian Palace of Advocates and mediators, SROs, play a very important role in raising awareness. Speaking of other ethical challenges, I would like to mention this competence and diligence before, during, and after mediation. And as you know, general ethical rule for a lawyer is to act competently and diligently while advising a client. And whether a lawyer considers advising a client on mediation and other ADR methods as an effective mean to resolve a dispute, that's a question. Under Armenian Advocates Code of Conduct, lawyer is obliged to take reasonable steps to solve the dispute through conciliation. Lawyer is also obliged to discuss reasonable settlement offer made by the opposite party. And the question is whether lawyers usually stick to these obligations. The other challenge is neutrality, whether to advise one of the parties or not, and when you have to speak as a mediator lawyer, you have to speak about a possible conflict of interest. What if mediator lawyer sees non-represented party goes wrong way? Shall he or she advise such party? Usually not at our end, but practices differ. And also, can a lawyer act as a mediator between existing or ex-clients? You know, this is also, it differs from time to time, but disclosures always need to be made before clients so that you keep your integrity and transparency for the parties. Then the last thing I would like to mention is additional ethical dilemmas for mediator. When mediator can stop mediation, for example, when should the mediator report or not about lawyer representatives violation during mediation, or shall confidentiality prevail? Facing fraud by one or both parties is another challenge. If a mediator lawyer sees there is a fraud, or a mediation is being conducted in order to make a fraud, shall it stop, or shall a mediator go to court and report about it? That's another challenge. So concluding my short presentation, I would mention that when a ethical challenge arises, then it becomes the task of the lawyer mediator and also professional networks and professional organizations to work together, to work through all applicable standards and rules, to conduct an attempt to comply with each standard and to find the fairest, the most fairest solution. Thank you very much.
Brilliantly done in 4 minutes, 57.15 seconds. I think you probably win the gold medal for the presentation. Thank you very much. Well, there's one or two things which I think we probably can take away from this. The first is the perspective that there are ethical challenges to mediators, which is maybe not something we think about very much. That we can think about the value of confidentiality, though that brings its challenge with, does the mediator report or not report matters which touch on ethics? Leave that as an open question. But all in all, I think it's been a fascinating session. I note that just looking at the chat, there's an interesting perspective from Afghanistan, where people are looking to wisdom. It slightly reminds me of the lawyer who was addressing the judge, and the judge, just wasn't following the argument, stared down at the lawyer after the lawyer had carefully expressed this detailed argument. He says, "Well, Mr. Smith," says the judge, I've heard what you have to say and I'm none the wiser." And Mr. Smith replied, "Yes, my lord, but at least you're better informed." I see that we've, sorry for you're all missing coffee, but I see, looking at the chat, that networking that normally happens over coffee is happening there. So that is also excellent. And I'll hand back to Rafal to take the conference on.